Welcome to another edition of our Justice and Pieces guest speaker series. Today I'm joined by Kim. Kim, maybe you could tell us a little bit about yourself, and thank you so much for joining us.
Hi, JP. It's a pleasure to be here. Thank you so much for having me. So, yes, my name is Kim Chonkrian. I'm the founder of Casey Legal. That's a paralegal firm based in Mississauga, Ontario. And basically, the bulk of the cases we take on and are provincial offense matters. And we do dabble a little bit in summary conviction criminal law. Um, yeah.
Okay, so Kim, maybe it's great because some of my students who may be listening to this are actually studying provincial offenses right now. So perhaps maybe you can kind of walk us through the steps in a provincial offense, like a Highway Traffic Act matter. So let's say, you are, I don't know, speeding on the 401 and, you're going 140 and it's Labor Day, so the police are out, getting ready to do their ride checks, and they sirens come on, they flag you down, they pull you over, they give you a ticket for being uh, 40 over the speed limit there. What happens next if somebody calls you and says, "Kim, I got this ticket yesterday on Labor Day. How do I fight it?"
Okay, so first, what would happen is that someone would call us inquiring with a ticket, especially it being about 140. I guess that would be in a hundred zone. We would ask them for a picture of the offense notice, and we would be asking them that what happened exactly when the officer pulled you over? What was your speed? What was your rate of speed? Were you in fact speeding? We would gather the information on what happened when the officer pulled them over. Did they say anything? Did they exercise their right to remain silent? Um, After that, we would advise them that you have 15 days to dispute the ticket and what their available options would be. Now, when someone calls Casey Legal, we tell them that we don't give guarantees. That's something we can't do. We do go over the options that they might have. So primarily, when clients call us, they're looking to see if their demerit points, which are usually associated with these tickets, if they can be withdrawn uh, in its entirety or if they can be reduced. We give them several options. So one would be that first of all, we need to look at the evidence. What does the prosecution have? Um, and based on the evidence, we'll be able to see if the um, what exactly is going to happen with your case. There are some instances where the Crown they can't prove their case and the elements surrounding the charge. In that case, we do not tell clients that hey, when we receive the evidence, there is high likelihood that your ticket would get withdrawn. In the case that the officer did um, do everything, and that the evidence seems full and complete, there we would be telling the client that, we do think that it would benefit them if they pled guilty to a lesser offense. This is another option that is available to them.
Okay, so let's look at we don't have to use the same example here, but so what do you like? What's the timelines in terms of responding to the ticket? Like, how long do you have to make a decision of what you want to do? Are there different options that you can do? Again, regardless of, our example had 40 over, maybe they didn't know they were 40 over. Maybe the police were just guessing they didn't have radar. Who knows? But, maybe it's something like a stop sign, right? That they said that they stopped, or there was some reason for whatever the behavior was. What are the different things you need to do once you get the initial infraction?
So the primary thing you need to do is dispute the ticket. You need to dispute it within 15 days, otherwise a conviction can come on your record. You have three options that are usually on the back of an offense notice. You have an option to pay the fine, you have an option to set an early resolution meeting with the prosecution, and you have the option of setting the matter for trial. You need to exercise one of these three options within the 15-day period um, to move your matter along. The after the initial after you would dispute the ticket, the next step that you would do after that is request your disclosure, and that's the evidence that the Crown has um, against you in this matter. I guess
Sorry, I was just gonna just say then, um, is there any advantage to just paying the ticket right there within 15 days? Like what else can you do if, even if you think, hey, I did it. I was speeding, they got me. I'm so sorry, but in today's economy, I just can't afford to pay this. Like, is there anything else I can do, from 40 over? Like what's the options?
so. You definitely can, with full remorse, you definitely can um, have a plea to have the fine reduced if you do want to plead guilty. But I would say that I always recommend clients definitely, you know, get your disclosure, see what the Crown has against you. In that case, you're able to see, you know, if you do want to plead to a lesser charge, you do have that option. If you do want to plead to the same charge, then yes, you do have the option of um, pleading guilty, but making submissions in terms of, you know, having the fine reduced because yes, times are tough right now. The economy is not that it's not great.
Okay, so now let's say then, as you mentioned, lesser charges. So can you give maybe an example of where, again, if it is going to, and I think, overwhelmingly most of these matters end up with a resolution of some kind. Some might get withdrawn because the officer's not there, I suppose. We could talk about that later. And then very, very few end up in a contested trial. But what would be a way in which you can look at resolving a matter? I mean, obviously, speeding, you can go to the next level down, but some of the other ones that you can resolve by way of a lesser and included offense.
So there are certain types of offenses, like let's say careless driving, that carries 6 demerit points. What we find is after some discussions with the Crown that they are willing to bring it down either to a 3 point charge or a 2 point charge. A 2 point charge that they often are willing to accept a plea to is disobey fine, which is under Section 182 Sub 2 of the Highway Traffic Act. And it's either we find that that's a very common one, even when it comes to speeding. Um, the it could be disobey sign in regards to careless driving. Like you mentioned, speeding. Usually they reduce the quantum of speed, which results in lower demerit points, and even change lane not in safety. Sometimes we find that there are even charges that you can plead to that don't carry demerit points, but they are minor charges like improper stop, drive in contravention of license conditions. That's a popular one that gets that the that clients end up pleading to, especially when it comes to cell phone, handheld communication device offense notices. They often get reduced to, driving contravention charges.
Okay, perfect. So when people, as you brought up the merit points, and they said, "Well, I can't afford any points," maybe you could tell us a little bit about, again, as you've alluded to there, how there's, essentially, if it's this offense what carries this points, like careless driving, and six, if you're found guilty of it, you're getting 6 points, right? Is there anything you can do about that, or as you said, the only ways to find a lesser and included offense?
So I do find, especially with in our practice, we deal a lot with commercial truck drivers. They're very concerned, like other drivers as well, about demerit points. They want to know whether or not their demerit points are going to be removed, whether or not how many they have, how many will result in a suspension of their license. And we always tell clients this. Now, with careless driving, for example, you have 6 points. We have to initiate those discussions with the prosecution and see the charge that we are going to be pleading lesser to. It has to sort of align with the situation that happened. Now, we can't have, you know, we can't have a careless driving charge and then, it's very unlikely that they would plead to something like, windshield not being like a windshield charge of any type. It has to be sort of related. We do try to take a look at the demerit points. And reduce them as much as possible. But demerit points that when you start getting into that, it's a little tricky. Everybody wants when they get a Highway Traffic Act charge, they are always kind of wary about how many points they have, and we do have to look at the disclosure before we can, make any further calls about it.
So in terms of that, then like what's that? So you've mentioned obviously, let's say they come in, you say, okay, let's put this down for trial within the 15 days. What is that initial conversation like with these clients? What do you need to go over and explain to them in terms of getting prepared for the rest of the process?
When we when a client instructs us that they do want to go forward with trial, we dispute the ticket and we do file it for trial. We do let them know that the next step, which will occur, is that the court will send the individual a trial notice. Now, most courts, if not all, they send the trial notice directly to the driver. And we do inform the client that right now there is a backlog and be patient. It does take anywhere from 6 to 12 months, varied in different courts, and that to regularly check your mailbox, they should be getting the trial notice. If you move, let us know. We won't know when the trial notice is, so we do check online, but always recommend clients to check your mailbox. They should be getting a trial notice from the court to provide that trial notice to us. And the next step from there would be that once we have that trial notice, there's a date that's set. We would be requesting the disclosure, and then from there we would be preparing for the trial, going over all the details with the client.
Okay, so now in terms of that, um, what about if, let's say, your client is unable to be there one day, like you have the date set down for trial, they are sick, they're out of the country. How do you go about getting an adjournment, for example?
Well, as soon as possible, we understand that emergencies happen. uh, you know, in this case, if someone's sick or they're out of the country, well, we hope if someone is planning to go out of the country and they know about it, that they inform us, because that is, informing the court, informing the prosecution as soon as possible is always important. They're more likely to sympathize with us and grant that adjournment. But in any event, emergencies happen. And in that case, we would file a notice of motion to adjourn. And that's a motion where we need to include the details of the reason, the court date, and the offense information. And we would send one copy to the prosecution, one to the court clerk, and of course, we would need to present that in one way to the justice that's presiding, so they have one copy available. And then in some cases, we would be provided with a motion date where we would attend and seek that adjournment.
Now you mentioned disclosure, and I think at the beginning you said you started to do a little bit of summary conviction matters. Maybe you can share kind of how that process is different, in provincial offenses with summary conviction matters, because there are a lot of people the other way who are seasoned paralegals doing summary conviction matters, and then they decide, hey, I have a client. They also have this traffic ticket. They ask me if I can take that as well. And how are those processes maybe similar, and how are those processes different?
So we just started getting into summary conviction criminal law matters, and I have to say that for some reason I thought that there would not be that many differences, but there definitely are. There are more penalties, more consequences than traffic tickets. The process, even from requesting the disclosure to, communication with the Crown, the even the fingerprinting process before, I would say that um, there's a lot more detail, a lot more um, requirements when it comes to summary conviction criminal law matters. And th- it's, I would say it's night and day.
So maybe you can go over then how to get disclosure in a provincial offense or traffic ticket matter, right? So you said, okay, no, there wasn't a stop sign; it was blocked by the tree, or I came to it, whatever it is, and now you want to get the officer's notes, and you want to get maybe there was an independent witness that filmed it on their camera or something. Who knows? How would you go about getting that in a traffic ticket matter in, let's say, Mississauga or Toronto?
So in Mississauga and Toronto, I've noticed that the ways to request disclosure, sometimes it does vary. So that would depend if it's an offense notice, a part one or a part three matter. For part one matters, like in the instance we're talking about for offense notices, there are disclosure request forms that are available on the court website where you can input information such as the name of the defendant, the offense date, and the defendant's address, their contact information, and you will receive a submission form confirmation. Make sure you keep that link because that's very important. Sometimes disclosure requests, they go missing or the prosecution doesn't see it. It's very important to keep that link, the submission confirmation. And once you complete the disclosure request form, it sends that notice out to the prosecution where they would contact you via your contact details, your email, or if you even have an option to pick up the disclosure from the courthouse, if that's available with that court. In Mississauga, I believe that is possible. So if you have chose the option of uh, wanting it delivered to you electronically by email, the prosecution will send it out to you by email. That should include the officer's notes and any witness statements, if they're applicable. And if you have selected the option for having disclosure ready to be picked up, they will contact you by your phone number on when you can do so.
Perfect. So, again, then in getting ready, you mentioned if it were to go to trial, what are ways that you would prepare with your client? Now you've got all that disclosure. It has what they're saying the issues were. It seems like they can't afford like a commercial truck driver to get any kind of penalty, the insurance consequences, all of that. What do you look at then in getting them ready for a potential trial?
So we do go over uh, like we have a pretrial sort of detailed consultation with the client. We go over the elements of the offense. We go over if there's any witnesses, what the witness statements say. We go over an important one is if this was a speeding charge, and if the officer reduced this roadside, um, and if the client insists that we're going to trial, that they should know that, if convicted, that the prosecution will be wanting to proceed on the original charge, not the reduced charge. We do inform the client of all the cautions, um, what can happen at trial. Obviously, if the officer doesn't show up, that the ticket will be withdrawn, as well as about how we would be basically about how we would be asking them questions. We would be going through preparing them on how the prosecution would be asking them questions and preparing them because especially I've noticed with clients when they're, any type of trial, they do get nervous. So it's very important to talk to them and ensure that, they have that support that they need, that they are readily prepared so that they can go in there confidently and not be nervous.
Now, I mean, one of the things that I think, in doing provincial offenses and traffic tickets especially is how do you explain sometimes like, the cost of paying just the ticket is going to be more than hiring you. So how would you explain that to clients when they're coming in and they're saying, well, how much is this going to cost me? Why don't I just pay the ticket instead? I mean, obviously, I think some of the commercial truck drivers understand the consequences with insurance, but I mean, the average person maybe not see it that way. What do you do to sort of walk them through that step there before, I mean, we even get to the trial happening?
Well, ask them, well, what are you planning on doing in the future? Are you planning on driving? We have a lot of Uber, third-party delivery drivers, and like you mentioned, CMV drivers. So they're aware. Most of them are aware of, how this impacts their livelihood and, the points and how this would affect them having a conviction on their record. But even um, clients who are not in the driving profession, we do let them know that, having these points on your record, it will impact your insurance, and your insurance will go up. Um, Sometimes we do let them know that, there could be a chance that, you know, your fine can be reduced or your points could be reduced. And it's very important that you keep your record clean. Your record is very important, your driving record. And the more points that you accumulate on your record can result in, I know primarily the MTO sends out a warning letter, and then the next step would be a driver improvement review. If you keep paying these tickets with these points, you can also, close to about 15 points, you can get your license suspended. So there are other implications from just paying these tickets with the points, not just with the ministry, but with your insurance as well, especially with insurance being so costly nowadays.
Now, earlier you'd mentioned, and I think, a lot of people say, hey, well, the officer doesn't show up, we're going to win then. Are you finding that that's still happening with things moving more virtually, or how do you kind of temper, a client expectation on a withdrawal that, they feel confident that might be happening? And then how do you pivot if they do then show up? What do we do?
So I do get a lot of clients who reach out and they mention, I've heard that if the officer doesn't show up, my ticket's getting dropped, the charge is getting withdrawn. And I like to remind them that pre-COVID, this might have been the case, but post-COVID, especially with Zoom being available and virtual court being available, officers can now attend via Zoom, and that makes it a little easier for them to attend. And I find that, especially in my experience, that officers do attend. I find more often than not they do attend. So I like to tell clients that, hey, I think that we should go prepared. That's the right way, and not rely on the officer's availability or their attendance, because that's something that's not in our control. that's betting on something where, if the officer comes, we're going to trial, and at that point, we have to sort of, it's not, the ball is not in our court 100% at that time. Better than relying on the officer's attendance, we should be prepared before. And especially with, Zoom and all these virtual advancements, um, we find that clients do understand that, officers do appear.
So I guess now, if they are appearing there, any tips or strategies there for any newly licensed or students listening in terms of, um, let's look at one, making submissions as to what the penalty should be. Again, we've talked about obviously trying to resolve it with the prosecutor, find the lesser offense. So maybe that's all done. But about what about like the actual penalty within that offense, as there's a range? Would you go about convincing the justice of the peace there to give leniency on your client there?
So we find that um, when there's a heavy fine, and we do want to make submissions, we do make them under Section 59 Sub 2. And what that section allows is, if someone is facing a very, exceptional circumstances, you know, they have, in some cases, dependents, or they're facing financial difficulty, and it's exceptional and it's extreme, that we can make submissions in regards to the fine. In some cases, like in our practice, there are heavy fines, especially when it comes to driving without insurance. Um, Part 3 matters especially, and you know, clients do ask for the fine to be reduced, and in some cases they do, and in some they don't. It really depends on their individual circumstances. Now, there are some clients where they're facing extreme financial difficulty, and you can make, you know, newly licensed paralegals can note that you can make submissions, but the situation has to be, um, it has to meet a certain standard, and it is in the JP's hand, how much they would want to do. But it's best to let the client know that, you know, that should be reasonable amounts that, that can be reduced. Now, of course, if your fine is 5,000, the court's unlikely to, reduce it 4,000 and leave you back with a 1,000. But I found that there are instances in extreme situations where the fine would be 5,000 and the court would reduce it, 4,000, reduce it 1,000, so it resulted in 4,000. But it, it's uh, it's a case by case basis, and it does vary. But you can make those submissions in regards to the penalty.
Now, I guess we've kind of got to the end there of the process there. So I don't know if you want to recap and maybe share any final thoughts on preparing for a traffic ticket matter that you think would be useful for students and newly licensees listening.
I would say, be prepared. How much you think you are prepared, you can definitely prepare more. Go over everything. Go over the disclosure. Go over case law. Discuss with your client. I find that, especially in situations where there's an accident involved, go to the scene if possible. It's, try to reenact what happens. Obviously, like, go see the area. If it's involving a disobey, a stop sign, check, is a stop, go to the location, see if the stop sign is, if there's anything covering it. um Prepare yourself and prepare your client. Be confident. um you know I found that in the beginning of my practice I was a little nervous. You know Going to trials, I felt that, especially when there were observers and other, uh, people in the court. But I would say that especially if they're regular members of the public. They're equally as confused. You know, you do have you do have experience, you have done theory, you have um, you know, done your internships, you do have what it takes, and you just uh, need to be confident and you need to do your best.
Now, switching over from provincial offenses into maybe running your own practice. So maybe you can kind of go back to sort of at the beginning where I was asking you a little bit about what you do, and maybe you could tell us how you got to running your own firm and what those challenges have been, and what are things that if you can go back before you started, you would tell yourself, here are the things you need to be aware of so that anyone listening that is thinking about running their own firm one day, whether they're a student or already in the process of doing so, that they can learn from that experience.
So I've always wanted to start my own firm. Uh, Ever since I graduated from Sheridan, where I got my paralegal diploma, I have wanted to start my own firm. It does come with its own challenges, but it's very rewarding. You get to choose your own practice area, your own time. You get to be more in control with your work life balance, and you can set your own schedules. And especially if you are a natural, you know, leader and you have those qualities, this is something that I would I would highly recommend.
Perfect. So, Kim, thank you so much for taking the time and joining us here today. Perhaps if you have any final words of wisdom for any of the students that are listening, any newly licensees, anything else about yourself or your practice that you wish to highlight as well. And thanks again for taking the time and joining us today.
Thank you, JP. And I guess if I had some final words of wisdom, it would be that the students and newly licensees don't be afraid to ask questions. Uh, you know, questions, there's no wrong question. Ask questions, um, volunteer after you're licensed, try shadowing someone, get all the experience that you can, get connected within your community, stay positive, and see every challenge as an opportunity for growth. And um, and yep, you can do this.